Good afternoon or morning, depending on where you are joining us from today. My name is Jennifer Roach. I am a partner in Thompson Hine's Antitrust, Competition, and Distribution Practice Group. I would like to welcome you to today's webinar. This is the 7th in a series of webinars targeted at issues that businesses face operating in a COVID-19 world. Our next scheduled webinar is June 23rd, and it is titled The COVID-19 Pandemic's Impact on Selling to the Government, Opportunities and Issues Facing Contractors. We are planning additional webinars as topics arise. To sign up for those webinars or any other, please visit our COVID-19 task force page. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many questions as time allows at the end of the webinar. We will be offering CLE credit for today's webinar. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located on the right-hand side of your screen. The form provides instructions as to where to send the completed form. You will need a tracking code, which I will announce at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides and the bios of today's speakers. Again, thank you for your interest, and if you have questions as we go along, please use the question box. I am delighted to introduce my colleagues that will be presenting today. Joining me are my Thompson Hine colleague, Matt Riding, a partner in Thompson Hine's Antitrust, Competition, and Distribution Practice Group, Darcy Brosky, an attorney in Thompson Hine's Antitrust, Competition, and Distribution Practice Group, and Jamar King, an associate in Thompson Hine's Business Litigation Practice Group. Darcy will be starting off the presentation today, talking about sales promotions, contests, sweepstakes, and charitable partners. So Darcy, please continue.
Thanks, Jen. Hi everyone, and thanks for joining us today. I'm going to get us started by talking about some of the issues you want to consider before you're going to run a sweepstakes, a contest, advertise a charitable partnership where you donate some of your sales to a charity, and any issues that are new to this COVID environment that you'll want to consider when you're structuring your sweepstakes. So I'm going to get started with a brief overview of the legal framework and the various laws that are in this space that you need to consider. And then I'm going to go into the difference between a sweepstakes, contest, charitable partnership, and kind of highlight some of the unique issues that apply to each of that type of promotion. Next slide. As you can see from this slide, there is quite a bit of legislation and other legal considerations in this area. It's kind of a hot spot where you've got to avoid a lot of different potential liability. First, I'm going to start with your big boy, which is the state lottery laws, which provides that only the state can run a lottery. And under these laws, a lottery consists of 3 elements: consideration, luck, and a prize. So to make sure that you are not running an illegal lottery, you need to get rid of one of these 3 elements and not have your promotion be considered a lottery. And we're going to get into that as a sweepstakes or contest being the 2 main options for eliminating one of these, the requirements. We'll get into that in a few slides. There are also state contest and sweepstakes laws which require mandatory disclosures. They require sometimes registration or a bond if your prize is big enough or if you're in a certain location. And they also have other particulars about how the contest can be run, how the sweepstakes can be run, and what you need to tell people and how you follow through with that. You can also possibly be dinged under the FTC or state Unfair and Deceptive Trade Practices Act if you are doing something unexpected, if you're taking advantage of consumers in some way, or you're doing something else that could be considered unfair or deceptive. Also, you can get into a breach of contract problem where your official contest or sweepstakes rules will be a contract with anyone who enters the contest or sweepstakes. So if you do something other than what you provided in those rules, you could be looking at a breach of contract or a quasi-contract, if a contract has not been formed, but somebody has taken some action in furtherance of your promotion. There's also foreign laws. So if you're going to try and have your sweepstakes outside of the United States, you want to make sure that you are appropriate in those jurisdictions as well. Canada has one interesting thing where they don't let you have a sweepstakes at all. So if anyone wins a sweepstakes, they need to answer a math question before they're allowed to claim the prize. And that's just one kind of interesting thing in Canadian law, and there's a lot of other things like that depending on what jurisdiction you're in. So you need to look at everywhere the contest will be open before you come up with your rules. If you are doing something with a charitable partner, you need to look at the state charitable partner laws. And then also, if you're running a promotion on social media, you need to look at what is permitted on social media websites, because you could be violating their terms of use with your promotion. Next slide. Okay, so as I mentioned, many states have a sweepstakes or contest legislation. And usually it requires that before running your sweepstakes or contest, you have official rules that need to disclose, one, an alternate means of entry if that's appropriate, that the alternate entries are going to receive equal weight, no purchase necessary, odds of winning, opening and closing dates of your promotion, how and when the winners are selected, the approximate retail value of prizes, and some others have other specifics. So those are the main ones that are pretty universal. So they also require you to contact the winners, which seems pretty obvious, but you have to do that, and follow through with the prizes. Again, pretty obvious, but you are under law to actually give the prizes you said you would. Additionally, some states are going to require that you register and provide a bond if there's a certain prize threshold. Florida, New York, and Rhode Island specifically, although Rhode Island is only applicable if you are conducting the sweepstakes in person in Rhode Island. So usually you can avoid that. But you want to avoid a price threshold if you're open to Florida and New York. And also they require sometimes that you make public the list of winners on your website as kind of a check that you actually did do what you were supposed to do with the promotion. Next slide. Okay, so the first type of promotion you might want to run is a sweepstakes. So as I mentioned, there's three elements to be considered in a legal lottery: consideration, luck, and prize. So the way a sweepstakes is run is it has luck and a prize, but it eliminates the consideration for entering. Now, what is consideration? It's the entrant giving something of value in order to enter the sweepstakes. Now, that can be money, which is how they do it as a lottery, but can also be non-monetary. It could be promotion, it could be going to a store, something that requires significant effort. That can all be considered consideration. Now, it has been somewhat unsettled whether or not having someone join a marketing list or promote the promotion on their social media counts as consideration. But in my opinion, if it has not officially been deemed that already, we're clearly going that way as people are becoming more and more recognized of the value of customer data and marketing and emailing lists. So if it's something that you could be paying to receive from a different format, such as an email list or a listserv, then I think you should be considering that consideration. And the way to get around this is if you are doing something like a mailing list, that's one of the most common, to make sure that you are not requiring consideration for enter, is you offer an alternate means of entry, which is some other way to join the sweepstakes without doing any consideration. The way we usually do that is a mail-in entry. So if you allow people to just write their name and contact information on something, mail it in, and then they don't get added to a mailing list, that counts as alternate means of entry. As long as you give them a valid chance comparable to the people that join the mailing list, you are good to go. And I never have anybody take the alternate means of entry because nobody wants to get stamped and mail something in. So it is a pretty safe way to protect yourself without really requiring any additional effort. Next slide. So here's an example that just happened of a sweepstakes that has gone wrong. Draper James is a dress company that is run by Reese Witherspoon, and she posted this on their webpage promoting this promotion. And now, as you can see on the bottom line where it says how, teachers can sign up via the Google form here to receive their free Draper James dress while supplies last. So they posted this, millions of people signed up to get their free dresses, and they only gave away 250 dresses. They said that it was actually a sweepstakes for the people who would get the 250 dresses. They would draw a name and those would be the winners. But as you can see from their promotion, that's not provided anywhere on their promotional materials. So what happened is, next slide, a lawsuit, which is what we all don't want to do. There is a class action that was filed in the Central District of California, and they are claiming that the class contains close to 1 million people for everyone who signed up to get the free dress. The claims are based on breach of contract or quasi-contract, saying that we performed by giving you our information and you did not perform by giving us the dresses. Obviously, we don't know how this case is going to go, but what I see to be in the potential takeaways is one, an official ruling that providing information or being added to a mailing list is consideration. And you can see that these are the people, they're upset that they gave their personal information, they got promotions, they got onto the mailing list. So they at least consider that they gave something of value to Draper James and did not receive anything in return. The second potential takeaway I think could be that while supplies last is not going to be an adequate disclosure if the amount of supplies are so limited relative to the amount of expected entrants. So had Draper James said, you know, first 250 to respond will get the dress, I think that would have been, they would have avoided the situation altogether. So while supplies last without more information is probably not going to cut it. And the other takeaway is try not to get sued, because now Draper James has this huge class action lawsuit. They were just trying to do a promotion, get some good press from it, be positive in the COVID environment, and it really went in the other direction and went poorly for them. So it is, and it's going to be a big cost to defend this class action lawsuit. So make sure you are, even if not just follow the laws, but make sure you're staying good with public opinion so that you don't end up getting sued. Even if you ultimately prevail, getting into a lawsuit in the first place is already going to be a problem. Okay, next slide. The second way to do this is a contest, which is where we take away the element of luck. You can have consideration in a prize, but then the winner is selected by clearly defined criteria and a judging process rather than by luck. Some examples include a photography or a photo contest where people vote on the winner, or you have an internal panel of judges that says, we are going to select the photo that has the most XYZ, and you define what characteristics you're looking for in the winning photograph, rather than just say, whichever one we like the best wins. You also want to clearly define who's going to be doing the judging. Is it an internal employee you are going to select? Is it, you know, some outside thing? Is it going to be the public? And that needs to be clearly defined and provided in the rules. Because you're getting rid of the luck element, you can require payment or other consideration to enter, except in these states I've identified, those are still no payment states. You can have the consideration, the effort required to enter the contest, but you can't have money or something else comparable, that type of thing to enter. Next slide. Okay, when you're running a contest, there's a few things that could be the potential hotspots that you want to keep in mind. The first is any intellectual property considerations, because as I mentioned, a photo contest is one of the most popular ones these days. You know, people take a picture of them using your product, they post it, you know, they try and get likes, you get positive feedback, positive press from it. But you want to make sure that the image or the video submissions don't infringe on anyone's copyright. You want to consider the background music, also logos or images that might be submitted. And you also want to consider that the submission may be made by the person in the photograph rather than the person who holds the copyright. So you want to make sure that you have a clear process of how you will deal with potential copyrighted images, claims of that, and make clear to the participants that they must own the copyright before they can participate. The second issue, which you've seen a lot in this COVID environment, is the data privacy issue. If it is a contest where you nominate a third party rather than you nominate yourself. So we've seen a lot of contests where it says, you know, nominate a teacher that has been going the extra mile during COVID, or nominate a frontline worker, in which case someone will be giving you personal information of their nominee, and they may not, the nominee may not want that information shared with you. So that's going to be a potential hotspot there. Also a right of publicity if the nominee doesn't want their image shown or they don't want to be shown on the promotional materials. You have to make sure that before you promote the winner, you have the permission of the person who's actually being depicted in the images. You also want to think about safety when you're designing your contest. You don't want it to be a race somewhere with cars or something else that could cause people to hurt themselves. In this case, something that could cause people to get together and possibly spread COVID. And also, if it's a contest you'll be having on social media, you need to keep an eye on general social media issues. You know, if people are bullying in your comments, or you have negative brand reflection or offensive content that people are just uploading, as long that you are not reviewing prior to upload. So those are a few things that if you're running a contest, you want to keep in mind as the big hot spots for potential problems. Next slide. So some of these I discussed just now with the contest regarding the nominating third parties issue. You also want to consider in this COVID climate that you may have supply disruptions. So that could come in the form of if you planned a trip as the prize, or if you have a certain number of products and there's now a shortage of products or a shortage of materials to make those products, how do you address that in your prize? The big way to do it is you want to have a force majeure clause in your rules, or something that says we have the right to change the rules, we have the right to change the prize to something of an approximate retail value in the event our prize is not available or the prize is no longer economically feasible. And also, when you're planning your prize, think in advance. It could be considered bad faith. If you plan a trip for the prize, you know there's a good chance the trip might get canceled and you won't have to follow through. So be thoughtful in selecting your prize in advance. And then also, if the prize is coming from a third party rather than from you, you want to make sure that you're only selecting reputable facilities and delivery companies so that you aren't contributing to the spread through sloppy packaging or sloppy practices. Next slide. All right, the last two things I have, is this has also come up a lot in the in this COVID area, which is if you are trying to do a promotion where you are going to donate part of your sales to a charitable cause. And before you do that, you want to be aware that there are state charitable solicitation laws. Generally, they require you have promotional rules which disclose who the sponsor is, dates of the promotion, specific products that are involved, percentage that you are going to donate, and the charitable purpose that your donation will support. So that would be, that would be an issue where you say, we're going to, from now until November 5th, we're going to donate 30% of our sales of this Nalgene bottle to help COVID efforts, containment efforts. You also need to separately track any sales that are subject to the promotion and then follow through and actually donate at the end. Next slide. A charitable partner is a little different than a charitable solicitation because this is where you actually are naming the person you are going to send your donation to. So you say, I'm partnered with the Red Cross and we are going to give 5% of our donations to the Red Cross, 5% of our sales. This is something that we call that a commercial co-venture, and a commercial co-venture agreement is likely required under state law. So that may mean that you need a written agreement with the nonprofit, in my case, the Red Cross, before you can start the promotion. Some states also require that you register with the state agency and or post a bond to verify that you are going to follow through on the donation. And also that you record, again, sales that are promoted, that are subject to the promotion separately so that they can be audited as needed. Next slide. And that is it for me. I'm going to pass it over to Jen to talk about price discrimination.
Thanks, Darcy. I'm going to spend a little bit of time talking now about the Robinson-Patman Act, which is a Great Depression era law that was designed to protect small mom and pop style retailers. It brings with it the possibility of treble damages for businesses using commonly used and often pro-competitive discounting practices, including things like volume-based discounts and annual rebates, potentially. So what does the Robinson-Patman Act prohibit? It prohibits discrimination in price between two competing resellers for commodities of like grade and quality. A discrimination in price just means any difference in price, not just the actual sales price, but you have to take into account discounts, rebates, credits, even reductions that may come in the form of payment for shipping costs. Additionally, early payment discounts or credit terms can also form the basis of a price discrimination suit. So there are two kinds of discrimination that are really the focus of litigation under the Robinson-Patman Act. Section 2A prohibits a seller from discriminating in price between different buyers, and sections 2D and E prohibit a seller from granting advertising and promotional allowances or services to customers unless they are available to all competing customers on proportionally equal terms. So this requires sellers to treat all competing customers in a proportionally equal manner, and we'll talk about what that means in a second. Section 2C and 2F relate to broker liability and buyer liability. Those are not often the focus of lawsuits. Exempted from the Robinson-Patman Act are nonprofits and direct sales to the federal government. And it's important to remember that the Robinson-Patman Act only applies to commodities sold for use or resale in the United States. It does not apply to services. And the Robinson-Patman Act actually doesn't define commodities, but it has been defined by courts pretty consistently to mean tangible goods. There are several elements that are necessary to establish a Robinson-Patman violation, and also some defenses that are available to companies, and we'll talk about those in just a few minutes. So when we're talking about litigation of Robinson-Patman claims, these are attractive to private plaintiffs in particular because of the treble damages that I mentioned, and the damages that are available can sometimes span several years of a plaintiff's lost sales or lost profits. So that's really where the action comes in. The government has had basically no enforcement for the past several decades, primarily based on a concern that the statute itself chills manufacturers and wholesalers in their pricing practices, their willingness to discount, and that it encourages rigid prices and actually rewards less efficient resellers. So the government's not really involved in this space, but there is a great deal of private actions and lawsuits. Robinson-Patman claims we see repeatedly are brought as counterclaims in unrelated business disputes. This crops up when a dealer or a distributor is terminated, there's a breach of contract lawsuit filed by a supplier, an attempt to collect on a debt that's owed by a supplier from a vendor, and sure enough, it's a reflexive claim that's brought that that manufacturer, that supplier, has engaged in price discrimination. And in this instance, we're talking about secondary line price discrimination or disfavored customer price discrimination. The allegations are that the favored customers of a supplier are given a price advantage over that plaintiff and the competing customers. Just this morning, there was a decision reported in the Eastern District of Missouri involving Monsanto. Monsanto had filed a breach of contract lawsuit against a seed dealer, and the lawsuit was basically for breach of this dealer agreement, and the dealer turned around and filed a Robinson-Patman Act counterclaim, and the Eastern District of Missouri denied Monsanto's motion to dismiss the Robinson-Patman claim. The seed dealer claimed there was an independent seed dealer, and they claimed that Monsanto, in their counterclaim, was selling seeds at $100 less per bag to large chain retailers, and the court said it was enough that the seed dealer claimed that they had lost sales due to their inability to compete with the favored purchasers, and that was the type of injury expected from alleged price discrimination claim. Now, we can certainly talk about whether that's the correct interpretation of antitrust injury that would have to be established, but this just illustrates the danger here for manufacturers and suppliers when they're facing these claims, because you can't guarantee that you're going to be able to win on a motion to dismiss if there are just some of these allegations made about lost sales or a long period of time, suffering price discrimination. That can also be seen by courts as enough to state a claim. There are also claims based on primary line price discrimination, where a manufacturer prices so low in a specific geographic market, for example, that it can cause injury to its competitors. But the Supreme Court in 1993 in the Brooks Group case basically said that these claims have to meet the same very high standard required of predatory pricing plaintiffs. And so these cases really aren't brought anymore. The focus is really on the secondary line price discrimination claims. So the elements of a Robinson-Patman 2A claim are listed here. I'm just going to talk about some of them briefly. The first seller makes two or more reasonably contemporaneous sales at different prices. Reasonably contemporaneous is a question of fact, and it depends on things like overall market conditions and the seasonal quality of sales. So it's not enough to say that it was within the same quarter. It may depend on actually what the circumstances are in the market. It doesn't mean that it has to be on the same day either. It can be a longer period of time. So the manufacturer, a wholesaler, or a distributor can also be the seller here. It's not just limited to a manufacturer or a supplier. When sale crosses the state line is another element that must be established. Third, the sales are of commodities of like grade and quality. We talked about how this doesn't apply to services. It also doesn't apply to leases, licenses, or offers to sell. It actually has to be a purchase. And when courts are evaluating whether the commodities are of like grade or quality, they look really at the physical characteristics of the goods and how that affects their marketability. The next element is the commodities are for use, consumption, or resale in the United States. The statute doesn't apply outside of the United States. And the sales are by the seller to two or more different purchasers. So this point comes up in the context of a bidding situation. Here, it's actually, the statute requires two completed sales, and courts have held that this element is not satisfied in a bidding situation where there's only going to be one commodity purchased at the end of that, that bid process. And finally, the difference in price may be to substantially lessen competition or tend to create a monopoly. So here, the transaction, the discrimination must be likely to injure competition. There must be a reasonable possibility of such an effect is basically the standard. And this is where the courts often get the analysis wrong. And like in the Monsanto case, why manufacturers get heartburn when some of these claims are filed against them. Many times courts don't apply the standard of requiring antitrust injury, and they require just the plaintiff to show that there was a price difference that resulted in a diversion of sales to a favored competitor, not that there was actually harm to competition itself. So the courts, in the way that they've interpreted the statute, have made this much more dangerous for manufacturers and suppliers facing these claims. One thing to note is that a transfer of commodities from a supplier to a company-owned store is generally not considered a sale. So it would need to be to a unrelated party for the statute to apply. There are some defenses to these Robinson-Patman claims, for sure, even some that are included in the statute itself. Section 2B of the Robinson-Patman Act provides an affirmative defense to sellers that act in good faith to meet an equally low price of a competitor. This is the so-called meeting competition defense. Section 2A also permits a cost justification defense, where you can offer a discount to a customer if there are differences in the cost of manufacturing, sale, or delivery of those commodities to that customer. This defense is very difficult to prove, however, and it requires more than just a quantity discount because this customer is ordering more commodities from you. It actually requires evidence or a rigorous estimate of the manufacturing or other cost savings that you're realizing by supplying that particular customer. Changing conditions is another possible defense. This really only applies if you're selling something like produce, where there are maybe seasonal applications or perishable goods that might affect the commodities. Functional availability is another defense, that if you are offering the lower price and making it available to all of your customers in the geographic area, including the reseller that says that they were discriminated against, and there was a realistic opportunity for that reseller to purchase at the lower price, then there will be no claim for price discrimination, because it's up to that reseller then at that point whether they choose to accept the lower price or not, and it negates the discrimination element of the claim. The second sort of category of litigation that comes out of the Robinson-Patman Act is in the promotional allowances and services area. These are Section 2D and 2E claims. The elements of these claims are provision of advertising or other promotional allowances and services in connection with the resale. It only applies to competing resellers again. And competing resellers is actually not as easy as you might think to determine, but it does require more of an economic analysis of whether they are competing, if they share the same customers, not just the label that they identify with or category of products that they're selling. Section 2D and 2E are per se violations. You don't have to prove harm to competition like you would under a 2A claim, but you still have to establish as a plaintiff that you've been harmed to recover damages. Again, 2D and 2E claims require two reasonably contemporaneous sales, that the commodities be of like greater quality, and finally, that the seller did not make promotional offers available to competing customers. So what types of promotional allowances and services are covered by 2D and 2E? The Fred Meyer guide that we'll talk about in a minute lay these out, but basically it's payment for offering advertising or promotional allowances, signs, displays, warehouse facilities, credit returns, prizes, or free merchandise for promotional contests. That's all covered by sections 2D and 2E. The Fred Meyer guides also refer to packaging as potentially being a promotional offer. There's a recent Seventh Circuit decision in 2016, which is kind of rare. These cases don't normally make it to the Court of Appeals, but an issue there was whether special packaging, specifically large and multi-packs, that were no longer being sold outside of warehouse clubs by the supplier was a promotional allowance. And the court said that it was not unless the promotional message on the packaging was something like a Halloween theme on candy, or, you know, a puppet or some sort of toy as a promotional inclusion with the product. There are also some defenses available in section 2D and 2E claims. One is that the supplier notified competing customers of the promotional payments or services. If all of the customers have been identified and they have had sufficient time to enable them to make an informed judgment about whether they participate in the promotion, then that is a defense to these claims. The second is that all customers have a practical opportunity to participate on proportionally equal terms. Now, this basically means that if you're going to offer all of your customers, let's say an allowance for TV advertising, and you have some customers that are so small they would never take advantage of TV advertising, you need to think about what else would be an equivalent for them, maybe direct mail or newspaper advertisements or something like that. The meeting competition defense that we just discussed a minute ago can be used here in response to a section 2D or 2E claim, but the cost justification defense is not available where the alleged discrimination is in reference to the allowances or services that are provided. Next, we've mentioned the Fred Meyer guides a little bit. These are put out by the FTC. They've got examples of what promotional services are in the guides. It's certainly not an exhaustive list, but it's a good place to start if you're thinking about these types of programs. There's a detailed discussion in the guides of promotional issues that may come up, and the purpose is really to provide some assistance on how you can best comply with sections 2D and 2E. Some of their advice that's particularly helpful is that promotional payments or services should be made under a plan. And in particular, the more complex or the greater number of competing customers there are, it's that much more important to put the promotional program in writing and have that plan locked in place so that there aren't any deviations from it. Again, that you have to take the step of notifying all of the competing customers. And the guides were last modified in 2014 to recognize that there can be competition between online retailers and physical retailers, but not much revision beyond that. I think folks were hoping for some additional guidance, but it wasn't provided beyond just sort of recognizing that there are online retailers. So what does it mean that the program is made available on proportionally equal terms? We talked about that a little bit with respect to the TV advertisements versus the news advertisements, depending on the size and sophistication of a customer. But really, any method can be used. But the most easily way to affect this and not run afoul of the Robinson-Patman Act is to make the promotional payments or services on a dollar volume or on a quantity of products purchased during a specific time period. Now, finally, with respect to COVID-19 concerns and the Robinson-Patman Act, Jamar will be talking later about pricing decisions in a crisis that could lead to claims of price gouging. But with respect to the Robinson-Patman Act, you also need to be considering your credit and payment terms that you're offering to customers, because they can be considered an element of price and result in potentially a price discrimination claim. The decisions that you're making about payment terms and credits and credit extensions may impact which customer survives of several competing customers. And those customers that don't survive and are out of business or are very, very much struggling could use this claim, particularly if you go to then try to collect money from them as a basis to as a basis for litigation and as a counterclaim in litigation. So what can you do to avoid Robinson-Patman claims by bankrupt resellers? First of all, have consistent standards for extensions of credit and payment terms. If the terms are going to be varied at all, then consider doing it by industry so that you're avoiding the two competing sales to competing customers. And then finally, make the payment programs available to everyone. Just quickly, two things to think about in your agreements with distributors or wholesalers or dealers is to include an arbitration clause. That would at least get you out of federal court, potentially out of some of these courts where they are having a broad interpretation of the injury that must be alleged to survive a motion to dismiss. It would help you bypass some of the expensive litigation that results from these claims. And then the last thing is consider a limitations period in your contracts with dealers, distributors. The Robinson-Patman statute of limitations is 4 years, but courts have said that if the statute of limitations in these types of agreements is of a reasonable period, maybe 1 or 2 years, then you might be able to head off some of these claims, particularly because they're brought, unrelated to maybe what the dispute may be by a disgruntled reseller. Now I will turn it over to Matt.
Thanks, Jen. I'm going to talk a little bit about fighting fraud and corruption in pricing and sales. And unlike, I think, what Darcy and Jen have talked about so far, where they've gone through specifics and statutes and how to avoid this, my discussion is going to be on a little bit higher level to talk about things that you need to consider, because in almost every instance, this is going to depend on your own circumstances as to where the risks are and how to combat those. Next slide, please, Jen. The fraud and corruption, as you have seen in the news and hopefully not experienced on a personal basis with your company, is running rampant during the COVID-19 pandemic. And this is something that some companies and industries have been forced to deal with and how to manage it, particularly in the medical supply and hospitals trying to obtain legitimate PPE, obtain masks and obtain gowns that are sourced from a authentic supplier and can source in large quantities. But this is something that affects everyone, because the supply chain as part of this crisis has been pressured in so many different areas and so many different points that there are fraud and corruption risks almost in every industry right now and in every business. And as businesses are pressured by supply chain challenges and by perhaps lower income and higher expenses, that can create opportunities that are rife for fraud or rife for people making mistakes and also attracting criminals. And this has implications both on the buy and sell side of your business, whether it's buying raw materials and inputs for a product that you manufacture and sell, or by selling and marketing your products to your customers. It's important to avoid issues of fraud and corruption, both from a legal standpoint and from a business standpoint, because if your product is subject downstream to fraudulent agents or to corrupt agents, that makes your product more expensive. If it gets on the gray market, that is something that becomes out of your control to control where your products go, and it becomes very difficult to manage your industry and your business successfully. This is something that 3M has had a major challenge recently with delivering 3M branded N95 masks to the market, where they're constantly having to manage and deal with fraudsters selling counterfeit N95 masks. Next document, Jim. This is a study that was done by the accounting firm Grant Thornton that showed that only 18% of the companies surveyed had a COVID-19 specific fraud plan in place. And TransUnion in combination reported that during the period of March 11 to April 28th, TransUnion identified 100 million fraudulent transactions only during this period alone. So despite that there is a significant volume of fraudulent transactions in the marketplace, companies are just ill prepared to deal with this. And having a plan in place to deal with fraud and corruption is something that is critical to success. Next slide, please, Jim. This is a slide that looks at the impetus to completing a transaction between the seller and the buyer, and the risks that a seller and buyer have to evaluate in entering into the transaction. And interestingly, many of the same risks appear on both sides of the ledger, whether a person is a seller or a buyer. And from from a buyer risk, you have a buy side corruption risk. You want to ensure that you aren't paying a higher cost for the product because of corruption in the supply chain. You're insured. You want to ensure that you're buying an authentic product, that it's actually what you intend it to be, and also that you can pay for the product in a way to ensure that the seller is actually going to receive the money that you're sending for the product, and it's not going to be something that is going to be stolen or otherwise you're accused of not paying. From the seller side, there's many of the same issues. They want to ensure that they are paid by the buyer. So how do you arrange payment and how do you structure the payment process when you may have a new buyer and a new seller that aren't familiar with each other, and you have to operate on trust? You want to ensure, if you are a seller, that you can tell the buyer that there is no counterfeit issues or there's no fraudulent sales. Likewise, if you're a seller selling through agents or selling through third parties, you want to be able to ensure that your agents and third-party sellers are actually selling your product and not falsely representing that they're selling your product, like we've seen with 3M and the N95 masks. And also, you want to avoid sales-side corruption, where you have intermediaries purportedly acting on your behalf that are perhaps demanding bribes or demanding corrupt payments in order to sell your products. This is particularly a concern in the medical industry right now, where the prices for PPE have gone much higher than anyone expected and much higher than the normal price, and people are demanding corrupt payments in order to make sales. Next slide, Jim, please. So in terms of evaluating these risks in your organization, I think you have to look at it from 4 different perspectives. You have to look at it from a controls perspective within your organization of, have there been any breakdowns or breaches in your controls process? Or are you one of the 82% of companies that simply don't have a controls process in place for related to COVID-19 fraud? In a controls environment where there's a lot of pressure to make sales or to get product to market quickly, it can be very tempting to disregard the controls process, to say, well, we don't need to do diligence on this particular sale. We don't need to worry about these safety measures that we put into place, because it's the time pressure to make the sale or to get the product to market is something that outweighs the controls process. But notwithstanding those kind of pressures, the controls process is something that still needs to be given consideration, about making sales and about when trying to bring your product to market, because it's important from a reputational standpoint that the need to bring a product to market quickly doesn't end up causing long-term harm to the organization due to a corruption risk and a potentially avoidable fraud or corruption risk that occurs because the proper controls weren't being followed. With respect to fraud and looking at the risks for fraud is, what processes are in place to combat fraud in purchasing and sales, and where is the risk for fraud in purchasing, sales, and in the pressure for financial performance. And so this is something within the organization that you would want to look at and say, as really part of the controls process as well, is where does our risks lie, and in what types of transactions do the risks lie? This is because in most transactions are going to occur without any fraud or corruption. But the transactions that do potentially involve the risk of fraud or corruption are also most likely going to involve a significant cost to the company, whether in terms of actual monetary cost or in terms of reputational costs. And these sort of outsized costs to the company, in combination with the low percentage of these types of transactions compared to the number of transactions that a company may have on a long-term basis, is something that can often be ignored because it happens in so few occasions. But it's important to sit back and monitor, where is the risks in sales and purchasing? Where is the risks in financial performance that fraud might be invited either by your employees or by your business partners? In corruption, the same kind of issues need to be taken into account too, is what sort of messages are you sending to your employees and business partners in terms of how you manage corruption in this kind of crisis? Is the message that you're valuing profits over ethics and profits over legality? Or are you continue to emphasize the importance of being dedicated to an anti-corruption program, being dedicated to an anti-fraud program, even at the expense of profits or an expense of a sale? And finally, with pricing, is how does your pricing strategy align with your company's goals? And what are the company's goals in terms of its controls and compliance program? And is the pricing being managed to only ensure that the firm is maximizing its profits, or is pricing being managed as part of a holistic strategy to ensure that the company's goals are being met throughout the crisis? Next slide, please, Jen. So with respect to your controls, there is, as we talked about, a lot of pressure to disregard the controls. But at this time, and especially in light of the crisis, the controls process has to be followed and enhanced. And while there can be adjustments made for timeliness in terms of the control process, it's not a time to say, well, we really need this source of supply, so we're going to buy it from this unknown supplier. that we've never done business before, and we're going to make that purchase without following any of our controls process. Or alternatively, on the flip side, if somebody shows up claiming to be an agent for a buyer and says they're willing to pay 2 to 3 times higher than the normal market price for your product, how does your controls process align with that particular sale, and whether you make that sale regardless of who that buyer may be? And if you're in the bank or the financial industry, you probably heard about know your customers, but it applies to all types of industries as well. And so it's important to consider your risk assessment in engaging new suppliers and customers, and how these people are evaluated. And finally, a lot of companies have found that their business model has changed with respect to the COVID-19 crisis, whether that's shuttering physical retail sales, or bringing products into new markets, or through new sales channels. And so how has your risk assessment changed based on your new business model? Next slide, please, Jim. So when addressing fraud, you want to take a look at, from the purchasing side, ensuring that your raw materials and other products are authentic and legitimate. Are you getting what you intend to purchase, and what steps and controls are in place to ensure that your purchasing department is doing what it needs to? And on sales side, as we've talked about, does the risk of fraud factor into your decision making regarding sales and pricing? Is there a gray market for the product that you're selling, and how does an illegitimate third party selling your product affect your strategy in bringing a product to market? And how are you managing customer trust when there are third parties selling potentially legitimate products or legitimate products outside of your control? And finally, how are your wholesale partners being managed? Are they selling a product for a price that is in line with your goals, and are they in line with your goals and strategies to ultimately bring your product to market? Next slide, please, Jen. And you can go ahead and skip this one. That's fine. And so, looking at your pricing goals and in your sales strategies as part of the COVID-19 crisis, to keep in mind that higher prices are not necessarily better. Part of this exercise is to ensure that sales and pricing goals should align with the rest of your company's values and compliance efforts. The Department of Justice has announced that it's going to continue to emphasize fraud and corruption despite the COVID-19 crisis, and that it will vigorously prosecute any offenders. And so you need to ensure that you're not feeling pressure to override these controls. And finally, you have to continue to be adaptable to change. So as the markets are changing as a response of the COVID-19 crisis, the legal and compliance must adapt too, and you can't continue to do business the same way that you have been. And I'm going to turn it over to Jamar now to talk about other issues related to pricing, which is unlawful hoarding and price gouging.
Okay, so as Matt said, I'm Jamar King. I'm going to talk to you guys a little bit about price gouging and hoarding. I'll start with a quick overview of what it is, and kind of explain why it's now a priority with the state and federal authorities, discuss some of the federal and state legislation in this area, and I'll discuss some of the recent enforcement actions and lawsuits that have been filed since the start of the pandemic. Thankfully, we've never really seen a national crisis as profound as the COVID-19 pandemic, so this area of law is relatively underdeveloped. There's no generally accepted definition of hoarding and price gouging, but if you look through various state statutes, you'll see a few common themes for both hoarding and price gouging. So what I have up there is hoarding is a collection or stockpiling of materials or supplies for the purpose of unlawful profiteering, and price gouging is the sale of certain materials, supplies, or services at excessive rates immediately after some type of disruption in the market. Next slide, please. On March 16th, United States Attorney General Barr announced that he was prioritizing investigation and prosecution of COVID-19 related wrongdoing. And about a week later, on March 24th, Barr issued a memo announcing the launch of the COVID-19 Hoarding and Price Gouging Task Force. In that same memo, he announced that the DOJ and the Department of Health and Human Services would be working closely together to develop enforcement measures and mechanisms to go after companies and individuals. As Matt said earlier, the DOJ is definitely going after bad actors, attempting to profiteer off of the pandemic, but they've been very careful to make sure that they're going after just bad actors, not normal, everyday Americans looking to kind of load up on the everyday necessities of life. So I just want to be clear that, if you're going out and you're getting things you need for your house, it's not quite the same thing as unlawful hoarding and attempting to profiteer off that. The task force is going to be led by the United States Attorney for the District of New Jersey, and at least one federal prosecutor from each United States Attorney's office across the nation is assigned to the task force. Similarly, state officials across the country have also made price gouging and hoarding top priorities after complaints have flooded their offices during the pandemic. Here in Ohio, Attorney General Dave Yost, after filing a price gouging lawsuit against the Cleveland area man, doubled down on his commitment to take a very aggressive stance against price gouging. Since that quote you see on the slide there, his office has established a hotline for reporting price gouging and a website for reporting price gouging directly to his office. Next slide, please. The only federal anti-hoarding and price gouging legislation currently on the books is the Defense Production Act. It allows the president to declare certain items as scarce or threatened during an emergency. And on March 23rd, President Trump issued an executive order delegating his authority under that act to Health and Human Services Secretary Alex Azar. A couple days after that, Secretary Azar published a list of items that he deemed scarce or threatened during this COVID-19 pandemic. So almost what you would expect, all types of PPE, medical face masks, N95 respirators, portable ventilators, disinfectant devices, gloves, masks, face shields, drugs containing chloroquine and hydroxychloroquine. And under the Defense Production Act, the Defense Production Act expressly prohibits and criminalizes the accumulation of any of those items in excess of the reasonable demands of business and personal use, or for the purpose of resale in excess of prevailing market prices. And that term right there is kind of key. The Defense Production Act doesn't provide any definitions of what in excess of prevailing market prices means, and there's no case law whatsoever on this, because this is kind of a new and novel area of law. As I said at the beginning of my presentation, this is a very underdeveloped, luckily and thankfully, this is an underdeveloped area of law. Violations of the DPA carry up to 1 year imprisonment and $10,000 in fines. And up until now, there had never been any prosecutions under the DPA. There had never been any criminal prosecutions under the DPA. Next slide. Oh, sorry, go back. In addition to the DPA, there's been a few bills floating around Congress. A few bills have been introduced to try to target price gouging and hoarding right now. Since we're short on time, I'm just going to discuss one of those bills. The COVID-19 Price Gouging Act would essentially make the sale of consumer goods and services at unconscionably excessive prices or for the purposes of profiteering off the pandemic illegal. Under that statute, that statute would include language that would make it a presumptive violation to sell any consumer good or service grossly in excess of the average price of the sales. Under that statute, it would be a presumptive violation to sell any consumer good or service at a at a gross markup of the price of at a gross markup of the average price 90 days before the sale. One of the issues with a lot of the new legislation is that it would only be tied to the COVID-19 pandemic. So, that will leave us kind of without anything should our nation face another crisis like this. Violations for not just the COVID-19 Price Gouging Prevention Act, but also the other bills floating around Congress would essentially be the same as a violation of the FTC rule or a violation of the FTC Act. Punishments would include damages, disgorgement of revenue, and up to $20,000 in fines for violation. Next slide. Um, 32 states, including Washington, D.C., has already had anti-hoarding and price gouging legislation on the books prior to the current pandemic. Generally, these statutes are activated after an emergency or disaster declaration by a governor or cabinet-level official. Some statutes provide explicit thresholds over which prices cannot increase during the emergency. For example, in California, a 10% price spike on consumer goods and services is presumptively unlawful. Other state statutes simply generally and vaguely prohibit excessive or unreasonable price increases. Most of these anti-price gouging statutes have safe harbors and affirmative defenses for price spikes that can be tied directly to an increased cost in production or other increased supply chain costs. Generally, the consequences for violations of these statutes range from civil penalties and fines to compensatory damages, and some even carry imprisonment. States without anti-hoarding and anti-price gouging statutes, such as Ohio, generally rely on a hodgepodge of other laws to prosecute hoarding and price gouging. The primary tools of these states are the consumer protection statutes, which prohibit unfair and deceptive sales practices in consumer transactions. Obviously, these are civil statutes, so they don't carry jail time, but they do generally carry civil penalties, and damages can be awarded for violations thereof. And additionally, in addition to consumer protection statutes, state authorities like Ohio have brought suits under various unfair competition statutes, antitrust laws, and ordinary private plaintiffs have also brought lawsuits for price gouging under theories of unjust enrichment. Next slide. So as I said before, this is a completely new time, this is a completely new area. What you see right there are some of the very first criminal prosecutions under the DPA. US v. Singh is actually a case that was the single first ever criminal prosecution under the DPA. Amir Deep Singh was a New York shoe and clothing retailer. He's accused of accumulating PPE, N95 masks, gloves, face shields, gowns, etc. by the thousands right at the start of the COVID-19 pandemic. And he turned around and he tried to sell them at markups ranging from 59% to, in some instances, 1,300%. The federal complaint against him alleges that his profiteering, or he was warned about his profiteering by the New York Attorney General, and he, even after a cease and desist letter, he continued trying to make deals and continued trying to sell his PPE products. US v. Romano is another case out of New York, another one of the first criminal prosecutions under the DPA. There, the criminal complaint alleges that a used car salesman falsely represented himself as an authorized 3M distributor and attempted to sell inferior PPE at markups ranging from 400 to 500%. He was even trying to work to get a contract with the city of New York to supply PPE worth approximately $45 million. Again, charges were brought against him for price gouging under the DPA and wire fraud. US v. Sharippa is kind of the one I found a little the most interesting. This was a pharmacist who no longer has a pharmacy, thankfully, but he was accused of He was accused of accumulating, selling PPE, and he labeled himself the Mask Man because he was making so many deals and selling so many masks. And one quote from the complaint, it says that he made a deal with an undercover DEA official where he was selling PPE, and he told the undercover DEA official that he felt like a drug dealer. And I thought that allegation right there of him feeling like a drug dealer really tickled me. So I just want to point that out. Again, all of these cases are cases of essentially cases of first impression under the DPA. Next slide. Of course, there's been some class action lawsuits as plaintiffs' attorneys have gotten in on the action. Each of the cases you see here are class actions filed in federal court in California. In McQueen and Mercado, the plaintiffs are alleging price spikes ranging from 50 to 674% on consumer necessities, including face masks, pain meds, flour, disinfectant spray. And all of these are charges that are well and above the pre-pandemic prices. The plaintiffs in McQueen are alleging that Amazon is not just a passive intermediary, but they are in control of not only their own inventory, but also they're in control of the prices of their own inventory and also the prices of the third-party sellers on its website. The plaintiffs in Mercado took issue with eBay's efforts to stop price gouging. They said that they were weak and ineffective. They said that simply removing certain listings or blocking certain sellers wasn't enough. eBay knew it wasn't enough. And in Fraser v. Cal-Maine Foods, that's a class action regarding the price of eggs. The plaintiffs are alleging that eggs had tripled in price since the start of the COVID-19 pandemic. And then I put that in there just to note that, these lawsuits kind of range a lot of industries. They're not just about PPE, they're not just about medical supplies, but almost any industry could become vulnerable to, almost any business could become vulnerable to a class action lawsuit. In addition to Cal-Maine, a lot of other players involved in the supply chain, the grocery supply chain, were named: Costco, Whole Foods, Walmart, Trader Joe's, and even some of the egg suppliers. So it really runs deep. In the Cal-Maine Foods lawsuit, this isn't the only version. The Texas Attorney General also filed a state class action in the state of Texas. And again, these are brand new, but there's been some very interesting theories posed under these class action lawsuits, very interesting claims that you should definitely pay attention to. Next slide. DC v. Helen Mart and New York v. Quality King are representative of some of the price gouging lawsuits that have been filed by state attorney generals across the country. In Helen Mart, the District of Columbia Attorney General is suing a convenience store under DC's anti-price gouging statute. Essentially, it's alleging that they sent a cease and desist letter, but the convenience store continued selling products such as bleach at markups up to 200%. And Quality King, that's a wholesaler that's accused by the New York Attorney General of raising prices on items such as wipes, disinfectant spray, to nearly triple pandemic prices. Both of these AGs are seeking injunctions and civil penalties. And the last case on there you see is 3M Company versus Performance Supply. Obviously, 3M's not an attorney general, but I wanted to include that because 3M's has been very, very aggressive at going after price gouging. As of today, this morning, I just got an alert. 3M's filed 12 lawsuits in federal courts against bad actors selling its products at unauthorized markups, and against price gouging, and against bad actors price gouging on counterfeit 3M products. The lawsuit has been filed in federal courts all over the country: Wisconsin, Indiana, Florida, New York, and California. Some of the theories are trademark infringement, fraud, and various deceptive business practice statutes. 3M's also been working with the DOJ to try to investigate and further find ways to go after some of these price gougers. So far, 3M's won 5 temporary injunctions and 3 permanent injunctions in its lawsuits. And again, it filed one just yesterday, a new one, I believe, in federal court in Florida. And so that was kind of a quick and dirty rundown of price gouging and hoarding and what's kind of going on and what's been happening since the onset of the COVID-19 pandemic. And I'll turn it back over to Jen.
Thanks very much, Jamar. We've run out of time. We're actually a little bit over time. I'm sorry about that. So if folks had questions, feel free to email or call any of the 4 of us or your current Thompson Hine lawyer. If questions were asked, we'll follow up with you by email during the presentation. If you are seeking CLE for today's program, the tracking code is TH0616. Again, the tracking code is TH0616. If you are not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Thank you all for your interest and attendance at today's webinar. Enjoy the rest of your day and stay well. And again, the tracking code for CLE is TH0616. Thank you very much.